Welcome to another edition of the TDF exclusive talks, and this time we have a UN Special Rapporteur joining us, Ms. Alena Douhan. Thanks for accepting to do this one-on-one interview with us. Could you please tell us a little bit more about what you do at the UN?
I'm the Special Rapporteur on the negative impact of unilateral coercive measures on human rights. That's one of the thematic mandates established by the Human Rights Council to focus on a specific topic. In my case, that's an impact of all types of unilateral sanctions as well as the means of the enforcement and over-compliance over human rights worldwide.
That's interesting. So can you please tell us, because when we talk about sanctions, well, they are intended to correct a bad behavior. How do you see that unfold?
That's an interesting question. Theoretically, I believe that the term sanctions used as today is quite misleading, because traditionally, from the legal perspective, we used to understand the term sanctions as something what is intended to introduce a punishment over the wrongdoer. But at the same time, the countries which impose that try to follow the same pattern, forgetting that many measures which are taken are against international law, and many purposes, many objectives, the announcements have nothing to do with correcting their wrongdoing. That's why in the title of my mandate, it's not mentioned the impact of unilateral sanctions, however, the impact of unilateral coercive measures. That means the types of unilateral activity which is not in conformity with international obligations of states and which have a negative humanitarian impact as well.
Where do we draw the line between sanctions and coercive measures?
That again comes from the legal qualification. Formally, states are not prohibited to apply different types of pressure over other states, and that's a nature of international relations. They try to influence the behavior as well as the policy of another state. But at the same time, in accordance with principles of international law, for example, the principle of the observance of international obligation, or principle of sovereign equality of states, the freedom of states to apply unilateral pressure or influence over other states is limited by international law. So therefore, for example, a state might decide not to become a party of international treaty, or might decide not to open a diplomatic mission, or to stop functioning of the diplomatic mission, or to decide to withdraw from an international treaty in accordance with the norms and the rules of that treaty. All that will be legal. We can call it sanctions, however, it will not be unilateral coercive measures as soon as it is in accordance with international law. There is also a narrow area which is called countermeasures, when one state violates international law in response to the previous violation of a specific norms of international law by another state. And under international law, that's mostly only the victim state, or any state, if we are talking about violation of collective obligation, for example, toward the whole international community, toward the perpetrator. But in accordance with the law of international responsibility, it's not a punishment in any way, and it cannot violate peremptory norms of international law, for example, principles of state sovereignty or prohibition of intervention to domestic affairs of states, and it cannot violate fundamental human rights. Naturally, states are also allowed to implement resolutions of the UN Security Council, but only in strict conformity with the scope of authorization given by unilateral sanctions. So what I have mentioned, so retortions, unfriendly but legal actions, countermeasures, and implementation of measures by the UN Security Council are the only mechanisms permitted by international law to act unilaterally. All the rest will constitute unilateral coercive measures because it will violate international law.
And how does the UN deal with that? Because you said that it violates international law.
The very first step for the United Nations, well, naturally we can talk historically about, for example, the Declaration on Principles of International Law of 1970s, which explicitly prohibits intervention to domestic affairs of states by all means, including economic, diplomatic, political, and so forth. However, in reality, the unilateral sanctions started to be used actively if we forget about Cuba, for example, which was a specific case. They started to be used actively since the last 20-25 years. And the first step which has been taken was the establishment of my mandate. So it's among the pretty new mandates. It was established only in 2015 to have at least someone within the United Nations system who will be able to do the expertise from the perspective of law, from the perspective of policy, and from the perspective of, let's call it, fact-finding, revealing what is the real humanitarian impact. One of the problems which exist today is that states cannot consent about the impact of sanctions and as well as about unilateral sanctions as such. As soon as states which impose sanctions, they insist that the activity is fully legitimate, not legal, legitimate and justifiable from the perspective of the higher objectives they are announcing. So they are not doing the legal assessment and they are not doing humanitarian assessment. And that's why they are always resisting launching of any UN mechanisms on that regard. So my mandate is an exception, and it's one among very few mandates, resolutions of which are not adopted by consensus, but rather than are voted.
And when we talk about unilateral coercive measures, which country has been using that as a mechanism for exerting pressure?
So at the moment, quite a lot. When we are talking about unilateral measures, I mean measures which are taken without authorization of the UN Security Council. That's why, for example, the, let's call them restrictive measures which are adopted by the European Union are also unilateral coercive measures. The list of countries which impose that is pretty clear, so that the United States, which imposed the most of unilateral sanctions, European Union, United Kingdom are extremely active in that area. However, we shall mention a number of other states, around 20, like for example Canada, Australia, South Korea, Japan, which are also using unilateral sanctions.
Okay, so here's the million-dollar question. These countries go the extra mile, violate international law in order to achieve some kind of objectives. How successful are unilateral coercive measures for the country that imposes them? Do they actually achieve what they want?
Well, eventually that is a question which goes beyond my mandate, and I'm not assessing whether they are successful. I'm assessing whether there is an impact and what is the situation from the perspective of international law. However, I might refer to multiple works which have been published also by the US scholars which claim that sanctions are not successful at all. But again, it's outside of my mandate and it's not my position.
And according to your mandate, what kind of effect do they have?
I'm mostly assessing the impact on human rights. And unfortunately, I have to admit with hugest regret that impact on human rights is terrifying. Naturally, some countries have better capacities to resist unilateral sanctions, and it usually depends on how sustainable the country is inside. For example, China is pretty successful. Iran is doing quite a lot to resist that. Russia is doing quite a lot. But at the same time, in some countries, like for example, Zimbabwe, Venezuela, or Syria, or Cuba, the situation is dramatic. Because the impact is incredibly high. It affects all categories of human rights, starting from the very basic ones, like for example, the access to internet. It's not possible to access many platforms, right to education and academic freedoms, because people cannot participate in any types of activity or research. And up to the different categories of labor rights and economic rights, because the lots of activities which used to involve import and export trade operations stop. Therefore, people lose their job, the inflation comes to many countries, and up to the right to food and right to health and even the right to life, because even in the countries which have quite developed system of healthcare and pharmaceutical companies, there are certain types of diseases which are pretty rare, and you might have the monopolist producer for the whole world which stops to produce medicine or to sell medicine for this specific country. That basically means that people suffer, people die, mortality rates are growing, and their life expectancy is reduced incredibly.
Thank you so much for your time.
Welcome.